Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn that subscription. For today's story, we are doing a follow-up on Nicholas Sandmann, the so-called Covington Catholic kid. You'll recall Nicholas Sandmann because he was definitely in the news everywhere for a hot minute. He was a kid who was attending a rally in DC, and then Nathan Phillips, a Native American, came up to him banging a drum, walking up to him banging a drum, and Nathan and Covington Catholic kid, our protagonist Nicholas Sandmann, kind of just stood there as Nathan Phillips, the Native American, just walked up to him, and then they had like a sort of staring contest of some kind where Nicholas Sandmann continued to just stand there and just like smile, because he, at least according to himself, said he thought the whole thing was bizarre and kind of just like, you know, whatever. And he got labeled the smirking kid by the media and all the rest of it. You'll remember that thing from Washington, D.C. Well, of course, a lot of it turned out to, the initial reporting, amazingly, turned out to not be true. The initial reporting said that Nicholas Sandmann was the aggressor. No, it was Nathan Phillips. Nicholas Sandmann had been standing where he was the whole time. Nathan Phillips was the one that walked up to him, not the other way around. Oh, it was Nicholas Sandmann who was trying to block him. No, it was Nathan Phillips, again, who walked up to him and just was trying to like basically walk through him. Even though Nicholas Sandmann was where he was sort of in a place where he had a right to be, and Phillips could have gone around him. It wasn't like necessary to go through him in some sense. Like, you know, maybe it was like a huge crowd and you couldn't really get out except by moving through the crowd. So it wasn't like that kind of situation. He could have moved around him without it being really an inconvenience, just chose not to. So a lot of the reporting on this was, of course, not great. And it was a major blow to the media. Well, Nicholas Sandmann, of course, was very upset about the situation and sued a whole bunch of people. Now, some of these lawsuits resulted in a settlement. So if you're thinking to yourself, I thought this case was resolved. Well, he sued many people, and some of these people resolved these lawsuits in part. So there was some kind of settlement that Nicholas Sandmann reached. For what amount of money, I don't know. People had been reporting huge dollar figures. I think this is very unlikely. I think that's much more likely that Nicholas Sandmann settled for tens or maybe hundreds of thousands. The numbers that were floating around with like tens of millions or tens of millions seems unrealistic. You know, I think the settlement was for maybe thousands or tens of thousands, and probably not much more than that, but who knows? It's a secret settlement. But not all the settlements occurred. Not everything settled. Some of them continued to go through to trial, including this one that we're going to cover today, which just got dismissed by the federal court. So there have been some earlier filings in this very case where they allowed the lawsuit to go forward, and the court's going to talk about this. So if you're thinking to yourself, wait a second, didn't I see an earlier video from Uncivil Law where the court said this very case could go forward? Yes, you certainly did. You definitely did see that video, because we got past the motion to dismiss, but we didn't make it past the motion for summary judgment. So we made it past the motion to dismiss upon reconsideration by the court, incidentally. And then there was some discovery, and then the court's like, nah, and has dismissed the case. After, well, you know, decided the case, I guess more properly, decided the case for the media outlets based on law. So we're going to go through this history, go through the procedural history, go through the factual history. We're going to, for the first time, we're going to see some deposition testimony from, well, we'll read about it anyway, more properly, because this is a written decision. But we're going to read some deposition testimony from the various people. We're going to learn a little bit more about what we discovered during the discovery process and why the court feels that this conclusion is compelled based on law, right? The relevant standard we're trying to reach, by the way, is that there is no material dispute of fact. And if there's no material dispute of fact, there's nothing for a jury to do. Then it just becomes what is the right answer under those sets of facts, right? So if we're doing a motion for summary judgment, what we're trying to determine is that there's no dispute of material fact. There's nothing for a jury to do. All the facts that matter are agreed upon. And if all the facts that matter are agreed upon, then it's just, well, what does the law say? There's nothing for a jury to do, because juries are a finder of fact. If there's no dispute of facts, there's nothing for a jury to do. All right. So with that in mind, let's go ahead and read this. All right. So the court's going to talk a little bit about the procedural history, which I'd like to go into, because it goes to show how these things process and how different things occur at different stages. And I think it's interesting. So the first case, because this, by the way, this decision is a whole bunch of cases. And you see the citations here in the footnotes. Sandmann versus New York Times, 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 versus CBS, versus ABC, versus Gannett, versus Rolling Stone. There's a lot of different people. There's a lot of different lawsuits that were happening. And this case is kind of resolving all those because there's a common nucleus of fact and law. So we can do them all for the price of one. Great. The first case filed by Nicholas Sandmann against the media defendants based on their coverage of the encounter between Sandmann and Phillips was Sandmann versus Washington Post, which was filed in this court on February the 19th of 2019. So more than 3 years ago at this point, it was filed. Sandmann alleges that the Post defamed him by publishing seven articles and 3 tweets containing a total of 33 alleged statements. So Sandmann said there were 33 statements that were defamatory. Sandmann filed similar complaints against CNN and NBC, respectively. The Post filed in an early motion to dismiss with the court granted after oral argument. In the opinion, the court held that none of the statements were actionable for various reasons. Some were not about Sandmann, some were statements of opinion, and some were not subject to defamatory meaning. Okay. So early on, the court said, motion to dismiss granted, right? There's no claim here. There is no statements that are possible to defame. 12b-6, failure to state a claim. All your purported defamatory statements are nothing because they're either non-actionable opinion, not subject to defamatory meaning, they're not about you, so forth and so on. So the court initially said, no, there's no legal claim here. All right, so Sandmann filed a motion for reconsideration and motion for leave to file an amended opinion. So Sandmann says, court, I think maybe you got that wrong. Have you considered not dismissing against me? So after oral argument, the court entered an order partially granting the motion to reconsider. The court said, you know what? As it turns out, I'd like to change my mind. Some of those things I said, I probably shouldn't have said those things. I'm going to reconsider. Now, good on the court, to be honest, right? At least the court, and whether or not the court was right or not to reconsider or not, at least it shows they were reconsidering. And they were willing to reconsider. So good on the court for being open-minded and saying to themselves, maybe I got this one wrong, right? This is asking the trial judge, by the way, where we haven't been to appeal, right? Because the first thing you want to do before you appeal is ask the trial judge, have you considered not doing that? Because if the trial judge says, you know what, I was just wrong, hey, you just saved yourself an appeal. Because the trial judge can reverse itself. The trial judge is typically not bound by its own rulings. So if the trial judge changes his mind, then, great. That solved the problem. So we got the trial judge to reconsider them in part, but only very much in part. The court's ruling was narrow. It only allowed one basis of statements. One group of statements that they blocked. The statements relating to Phillips statements that Sandmann had blocked and would not allow him to retreat. So I think of the 33 possible statements, I think it was 3 that we're going forward on. So very, very narrow set. So of those 3, I should have. I was a bit more premature. Okay. The court stated that justice required discovery be conducted as to context of those statements, noting the court will then consider them anew on summary judgment. The court reiterated this point at the end of its order, stating that while the allegations of the amended complaint pass the requirement of plausibility, they be subject to summary judgment practice. All right, so this goes to show how court proceedings occur at different stages of things, right? So the first thing out of the gate is the motion to dismiss. 12b-6, failure to state a claim. You have not stated on the complaint a plausible claim. None of these statements are potentially defamatory because of their opinion. They're not about you. They're not subject to a defamatory understanding. These ideas, right? None of these statements are defamatory on their face. Motion to dismiss. The court says initially yes, and then says no. let's have discovery. Let's have some limited discovery because maybe they are defamatory or maybe not. I'm not sure. But let's have just some discovery. And maybe there's some additional information that will come out in discovery that will resolve this question. And the court is making clear, which is, perfectly fine, that if we get to the end of discovery and there's nothing there, then the court reserves the right to reconsider its decision. Either dismiss or summary judgment. Either way, right? So it's like, then we get to the summary judgment stage. So either we say, okay, well, I'm going to dismiss now, or I say, there's no dispute of fact. So either one, I dismiss, judgment is a matter of law, you can't win under any set of facts, or option 2, summary judgment, you could win under some set of facts. It's just that you don't have any of those facts. Because at this stage, we've conducted discovery. So we now know, all the possible facts that could exist. This is the idea, right? We now know all the possible facts. And it turns out there are no set of facts under which, either there's no set of facts under which you can win, judgment as a matter of law, or there's no genuine dispute of fact, because you guys essentially, there's no disagreement, and then someone should win under summary judgment, because there's nothing for a jury to do. Okay, great. The court called 3 pending cases for a scheduling conference in January 2020. During the conference, counsel informed the court that Sandmann and CNN had settled, and Sandmann intended to file additional suits against other media defendants. So CNN decided to settle. How much they decided to settle for is unknown, but probably not very much. Probably not very much if I was a betting man. But, who knows for sure. When the parties agreed, the court thus deferred the completion of the discovery plan until new suits were filed and only preliminary suits were resolved. So we'd like to sue other people. Okay. So we'll do that. The 5 cases that are now pending, because in this lawsuit, now we've got 5 different people possibly that are being sued, were all filed of March the 2nd, 2020. However, the onset of COVID-19, changes in representation and resolution of the Rule 12 motions, which is the motion to dismiss, in the new cases, because those new cases also had motions to dismiss, which were of course denied for very similar reasons, slowed the progress until early 2021. So yeah, COVID and a whole bunch of things hit, and it caused a lot of problems in the court system. In March 2021, the court adopted the parties' proposed phase discovery plan, with phase 1 being limited to facts pertaining to the encounter between Phillips and between Plants and Phillips. So the court, in exercise of its judicial management, can order discovery in a limited fashion, in an unlimited fashion, in different stages, in different phases, right? They can do it in a lot of different ways. And it becomes an issue of, well, what will assist the court, right? And so the court seems to be thinking to itself, maybe I can decide this. It's thinking ahead to itself. It's thinking ahead to itself, basically, when it's issuing this in the first place. It's like, maybe enough information will come out in an earlier stage of discovery that I'll be able to dispose of the issue. So I'll order discovery in phases, because if it turns out that I can deal with the issue earlier on, then I can deal with it faster. There will be less discovery. It'll be less burdensome to the parties, faster resolution. So this kind of makes sense. The court could do this, could not do this. It's basically up to the management discretion of the court on an abuse of discretion standard. So the parties' joint planning report explained the plaintiff's case against the defendant would then be ripe for an early motion for summary judgment on whether the statements blocked him or prevented him are true or substantially true or otherwise not actionable. So, with respect to the claim that plaintiff blocked Nathan Phillips, we have a couple different possibilities. It's true, or it's substantially true, which is another way of saying any difference between the truth and reality is too small to care about, or it's not subject to being true or not because it's opinion, So maybe when we reach that stage of discovery, we'll be in a position to render a decision on those issues. It'll permit the court to rule at an earlier stage of the threshold issue. Makes total logical sense. If we can get to the answer faster, then great. Although phase 1 discovery has been completed, the only evidence filed in the record so far consists of Sandmann's deposition, a declaration under oath by Phillips, 7 declarations under oath by persons in attendance at the incident, and a collection of video recordings taken at the National Mall that day. So we have completed phase 1, and all the things that fall within the scope of phase 1 are the things we just described. Sandmann's deposition, Phillips's declaration, 7 declarations of witnesses, and a collection of video recordings taken at the mall that day. Okay, so let's discuss the evidence that we have to decide whether or not we should press forward, either with discovery or with the trial or whatever. What do we have so far? Okay, so Sandmann's deposition, Covington Catholic kid. Although lengthy, Sandmann's deposition contains relatively little testimony pertinent to the issues at hand, because the issue at hand we're trying to solve, remember, is the issue of defamation. We're trying to decide whether or not the media defamed him with respect to, I believe it was 3 very specific statements regarding whether or not Sandmann blocked Phillips and wouldn't let him leave, basically. So Sandmann probably is talking about a lot of things in his deposition, like, you know, who he is, where he came from, where he went to school, how we got to the event in the first place, blah 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 blah. But not a lot of it's really relevant to our immediate concern. It might be relevant to other concerns if we ever get that far, but we haven't gone that far yet. We're just trying to decide something very narrow at the moment. All right, so what's relevant to the narrow issue we're trying to deal with at the moment? Sandmann observed Phillips moving towards and then through the group of students. Some students moved out of the Phillips way as he walked forward. Sandmann felt that Phillips was trying to intimidate the students by walking right up to them, when he could have taken several other routes around him. So Sandmann felt like he wanted to stand up for his school. At the time, he did not know that Phillips' intent was to get up to the Lincoln Memorial. Which, you know, how would he? Phillips stood so close to Sandmann that the drum touched Sandmann's shoulder. His spit was getting on Sandmann's face, and Sandmann could smell Phillips' breath. The steps were icy, and Sandmann was concerned that if he moved, he might slip and fall. Sandmann felt that he was being mature by remaining calm and standing his ground in a tense situation. Sandmann can see how Phillips might perceive that Sandmann was trying to block his path. How could Phillips perceive it? Maybe. There was room for Phillips to keep walking if that's what he wanted to do. Sandmann did not feel that he was blocking Phillips because Phillips gave no indication he wanted to move forward. Like, could you move, or I'd like to get past, or trying to get to, nothing like that would let them know that that's the thing. Phillips gave no indication he wanted to move forward. Instead, he locked eyes with Sandmann when he was still several feet away from him, and then planted himself directly in front of Sandmann. Phillips did not even take the slightest step in any direction in an attempt to move. Which, okay. Which makes it a little bit hard to pin this on Sandmann. Sandmann is not sure if he moved a little to the left as Phillips approached. He either adjusted his footing and or the people around him shifted as well. At one point, Sandmann felt that he was blocked from moving because of the crowd around him, although he had no reason to believe that they would not move if asked them to do so. So he also felt Sandmann felt a little trapped, which if you've seen the video seems perfectly reasonable. But then again, he thinks to himself, well, they probably would have moved if I had asked them to. So, so that's what Sandmann says about the incident. This seems roughly in accordance with the tapes we've seen. What does Phillips say about the incident? Phillips' declaration, submitted by defendants in support of their joint motion, offers the following things. Other than a woman named Ashley Bell, Phillips did not know any of the individuals who joined him in walking towards the group of students. Okay, that seems plausible. As he approached the students, Phillips felt the crowd was swarming and surrounding me. As Phillips began to move towards Lincoln Memorial, students moved out of his way. However, Sandmann appeared to position himself in front of Phillips. Phillips declared, "It was very much my experience that Mr. Sandmann was blocking me from exiting the situation. It was very much my experience that he intentionally stood in my way in order to stop me from moving my forward." Okay. Further, I felt surrounded in that space, and I believe Mr. Sandmann did not want to let me pass. It seemed to me that Mr. Sandmann felt he needed to stand there and block my way. So that goes to Phillips' perception, apparently, of things, which, okay. Now we have some additional declarations from some other people. 6 of 7 other declarations are by individuals who attended the Indigenous Peoples March that day, which Philip also attended. Only one, Ashley Bell, knew Phillips from prior events. There was no planning among these people in advance of the incident in question. Rather, their decision to join Phillips as he approached the group of students was impromptu. 5 of the 6 individuals offer that was their impression that Sandmann blocked Phillips from moving forward. So that's what they say. We think that Sandmann was trying to block us. From their perspectives. Okay. The 7th declaration is from a classmate of Sandmann who was also with a group of the students on Mall. But that student had moved away from the group at the time of the encounter between Sandmann and Phillips and did not observe it directly. Well, that's not very helpful. If he didn't observe it, his testimony is of very little value. But we do have video evidence, which is going to be helpful. The parties have submitted 20 videos that capture scenes from the national malls on the day of the question. The parties have stipulated to authenticity and have waived any hearsay objections from them. Fantastic. In the court's view, 6 other videos show specific encounters between Sandmann and Phillips that are helpful to the court's analysis. So 6 of the 20 videos the court finds to be helpful to the point that we're trying to analyze. What a viewer might conclude from these videos is a matter of perspective. However, what's clearly shown and not subject to reasonable dispute is the following. So here are some things that the court thinks are facts now that are not subject to any reasonable dispute. Okay. Phillips began drumming and approaching the group of students, accompanied by several individuals who testified that, although they did not know Phillips, they followed him because he was an elder. Yeah. As Phillips came close to the group of students, some began to part, and Phillips continued to move forward. Eventually, Phillips came to stop directly in front of Sandmann. As Phillips approached, Sandmann suddenly adjusted his footing, but it's unclear if he actually moved from where he stood. So he might have changed which foot he was leaning on, which, you would do if you're standing for a long period of time. At least I do. I shift my weight from one side to the other. So yeah. At no point did Phillips ask Sandmann to move or attempt to continue walking past him. Sandmann also did not change his position while Phillips played his drum, although it was within inches of his face. The encounter ended when a chaperone attendant arrived and told the students their buses had just arrived. This is as far as uncontested findings of fact go. Sure, why not? All right. So what is the relevant legal standard? Well, as I've told you, we're trying to do summary judgment right now. Summary judgment is appropriate where there is no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. If there's no dispute of fact, there's nothing for a jury to do. Juries are finders of fact. If there's no dispute of fact, there's nothing for a jury to do. So then, well, what's the result? If no one wins, then dismiss. Because no one wins. But if one of them wins, then summary judgment. Right? So summary judgment. So yeah, if there's no genuine dispute of fact, then either no one wins, in which case dismiss, or someone wins, in which case decide for them. What is a fact that's material? What is a material fact? Well, its fact is material if it might affect the outcome of the suit under the governing law. All right, so what makes something a material fact? A material fact is something that changes the probability to any degree of any of the elements of the charge, whatever it would be, right? So for defamation, that's a false statement, a fact, communicated with a third party, blah, blah, blah. You know the drill, right? So what is a fact? Well, what is evidence? Evidence is anything that would make something more or less likely. That's one of the elements of defamation. If it's not one of those things, then it's not evidence. It's also not a material fact because it doesn't go to anything that is relevant to the legal standard. Right? Does it relate to one of the things that forms the cause of action? And considering the evidence in record, the court must view the evidence in light of the party opposing the motion. So much like a motion to dismiss, in any sort of dispute of facts that might exist, the court must assume all the facts are for the non-moving party. Just like in a motion to dismiss, right? We've discussed this before. In a motion to dismiss, you are saying there is no cause of action here. There is no cause of action. What you're saying in a motion to dismiss is, even assuming literally every single word you say is true, you don't win. You have no case here. Assuming every single thing you say is true, you still lose. So there's no point in going forward, because the best possible outcome for you from a jury is they believe everything you say. There's nothing more possible for them to do. The best possible outcome from a jury is they believe literally everything you say and nothing I say. That's the best possible outcome. It can't be any better than that. So if that were to happen and you still don't win, there's nothing to do. And so in a summary judgment, it's exactly the same. Like, the court is going to assume, to the extent there is any dispute of fact, every single fact that's in dispute goes the other way, right? You can only win if you win under every possible contingency, under summary judgment, right? Otherwise, we go to trial and then we figure out which version. If there's any version that you can win on, we go forward. If there's no version you can win on, then there's nothing to do. So that's where we're at, basically, right? The court then notes that the court is sitting in diversity and thus applies Kentucky law, citing Himmel, which ultimately goes back to citing Erie, which, we don't have to talk about that much right now, but yes, Kentucky law is the relevant thing here, because we're trying to decide defamation law under Kentucky state law. So despite the fact we're in federal court, we're applying Kentucky state law, because that's how we roll. Great. All right, so law of the case. All right, so what is law of the case, first of all? Law of the case is the principle that as a case is developing, it generates its own law unto itself, because things are happening in the case and decisions are getting made. And so those decisions create law for the case unto itself. And depending on the situation about what's happening, that can be binding. The most obvious way that would happen is if some issue has already been to the Court of Appeals on, say, for example, an interlocutory appeal. So we've already been to the Court of Appeals in the middle of the case. We've already been to appeal on an interlocutory, and the Court of Appeals has rendered a decision. Well, that's law as it relates to this case now. So as we move forward, we have to apply that. But not necessarily only under those circumstances. That's just an example. So law of the case is the idea that things have happened in the case which are somehow binding on everybody. So let's discuss that possibility. Sandmann first argues the court cannot now consider this fact or opinion issue because law of the case doctrine. Okay. This argument's without merit. I mean, I would think so, but what's your argument that it's not? As noted above, the court expressly held that while the allegations of the complaint passed the plausibility test at the pleading stage and discovery should be had, the actionability of the statements would be revisited on summary judgment. Yeah. Further, the Sixth Circuit has held that the law of the case doctrine does not apply to earlier proceedings when a different legal standard governs, which is true in a case of a motion to dismiss versus a motion on summary judgment, right? The motion to dismiss is you can't win under any possible set of facts. The motion for summary judgment is, well, we know what the facts are, and you can't win under these facts. So there's different legal standards, so law of the case doesn't really work. It doesn't, no. Sandmann's insistent the court cannot now revisit the legal issue is ironic considering he vigorously and successfully moved the court to reconsider its earlier ruling. That's true. That there is some richness there, right? Hey, court, you can't revisit a legal issue, but you yourself asked me to revisit a legal issue earlier to your benefit. So yeah, I appreciate the court's snark and potential noting of hypocrisy. The court's not wrong. All the parties agree as to whether a statement is fact or opinion is a question of law for a court to decide. Yes. So, is a statement fact or opinion? That itself is a legal question. So, yeah. The court alone has to decide whether or not the statement is one of opinion or one of fact. That is definitely the law. Yes. As the Supreme Court has noted over 30 years ago, a statement of opinion relating to matters of public concern which do not contain a provably false factual connotation will receive full constitutional protection. Statements of opinion are not actionable. A viable defamation claim exists only where a reasonable fact finder could conclude the challenge statement constitutes an actual, objectifiable, verifiable fact. If it's none of those things, then not so much. You can only sue in defamation over facts, not opinions. Under Kentucky law, alleged defamatory statements should be construed in the whole context of the publication. That's pretty much standard law everywhere. A statement in isolation that appears to be defamatory might not be in full context, and vice versa. A statement in isolation that does not appear to be defamatory might be defamatory in full context. A statement must be understood in the context of the overall publication. Yeah. A publication must be read and construed in the sense in which readers to whom it's addressed would ordinarily understand it. The reasonable man test pops up again. Once again, our hero to the cause. How do we understand what this is to mean? Well, it's the reasonable man test. It's always the reasonable man test. We imagine in our mind a man of ordinary, common prudence, ordinary, normal education, who likes to ride buses and is capable of riding buses. The man on the bus test. The ordinary, average, common person of ordinary, normal, common intelligence. How would they perceive it? That's the relevant metric. The Sixth Circuit has also emphasized that it's important for the court to consider what a reasonable reader would take away from the alleged statement. Once again, what does the reasonable person understand? What does the reasonable man understand? That is our metric. A recent Sixth Circuit case illustrates this principle. The case involved a biologist who contacted the New York Times and other newspapers about statistical inaccuracies in scientific articles authored by a celebrated cancer researcher. That is a very specific complaint. The cancer researcher sued the biologist for defamation. Wow. The Sixth Circuit held that his statement, the researcher knowingly engaged in scientific misconduct and fraud, was protected opinion. Okay. I mean, that is some really petty bullshit there, though. I'm just saying. Apparently, there's some love lost between this biologist and this cancer researcher. I'm just saying. These people do not like each other. I can tell. This is some really petty bullshit between some petty people. I can tell what's going on. Okay. The judge who offered that opinion focused on what a reasonable reader would take away from the letter the biologist wrote. He concluded that reasonable readers would see there's ample room for a different interpretation of the evidence the biologist presented. What we're dealing with a reasonable man on the street. I'm not sure about that with the context of a biologist, but okay, yeah, fine. He further experienced that whether a set of facts amounts to misconduct is subjective. Okay. And we would expect people to have different opinions on the question. The biologist's statement was neither an assertion of fact nor a conclusion of logic that follows incontrovertibly from asserted facts as a matter of logic. Instead, it is a subjective take that's up for debate. Okay. See also Seaton versus TripAdvisor from the Sixth Circuit. Quote, readers would instead understand a list of dirtiest hotels in America to be communicating subjective opinions of travelers who use TripAdvisor. Wow. Citing also a case from the Eastern District of New York, finding a statement from an eyewitness who recounted the entirety of a police chase and said he saw someone block a police car was opinion, and a reasonable reader would not understand his words to imply undisclosed fact. Wow. Yeah, that's okay. Yeah. The Supreme Court has also emphasized that the setting in which the speech is in question is made helps understand the nature of the defamatory statements to be more understandable to the reader. For example, quotations allow the reader to form his or her conclusions and assert conclusions of the author instead of relying entirely on the author's characterization of her subject. Citing some case from the U.S. Supreme Court, holding that when speakers at a city council meeting characterize the plan's negotiation position as blackmail, a reasonable reader would understand it was not slander when spoken and not libel when reported. I guess the idea there is it's hyperbolic, not literal. Sure. These same principles are applied across many other circuits. In some, the court must ask whether a reasonable reader, in reading the entire article, will understand the statement in question is someone else's opinion or interpretation of the event or situation. Okay. Finally, if an alleged defamatory statement is a statement of opinion, it's actionable under Kentucky law only if it applies undisclosed facts. This is just a case, of course, generally true. This is generally true in defamation law. A statement of opinion can nevertheless be defamatory if the opinion can be understood to convey underlying facts, secret facts that only I know. Like, so then I'm in some sense conveying the facts through the opinion. So that's, it can happen, but yes. All right, so with all that law in mind, let's turn to the relevant statements and figure out what they are. Are they opinion or are they facts? The alleged defamatory blocking statement at issue are the following. Great. So what are we suing over? We're suing over this. It was getting ugly, and I was thinking, I've got to find myself an exit out of this situation and finish my song at the Lincoln Memorial, Mr. Phillips told the Post. I started going that way, and the guy in the hat just stood in my way, and we were at an impasse. He just blocked my way and wouldn't allow me to retreat. Statement of fact or statement of opinion? Okay. Applying the above legal authorities and with benefit of a more developed record, the court concludes that Phillips' statement that Sandmann blocked him and wouldn't allow him to retreat are objectively unverifiable and thus unactionable opinion. So, based on the precedent, he just blocked my way and wouldn't allow me to retreat is not fact, but opinion. I will simply note, for what it's worth, that this can get tricky, and it's an issue of law. And Sandmann has indicated he's going to appeal, which, because it's an issue of law, it's de novo for the Sixth Circuit about whether or not this is capable of fact or not. And I feel like his odds on the Sixth Circuit are not horrible. So Sandmann's planning to appeal. This is a pure legal issue. So that's what the courts of appeal are for. Is this a statement of fact or is this a statement of opinion? Okay. Instead, a reasonable reader would understand that Phillips was simply conveying his views of the situation. And because the reader knew from articles this encounter occurred at the foot of the Lincoln Memorial, he or she would know the confrontation occurred in an expansive area such that it would be difficult to know what might constitute blocking another person in that setting. Generally, blocking is an imprecise term capable of different meanings that lacks a plausible method of verification. Maybe, but wouldn't allow me to retreat? Even if blocking is a bit vague, which I can understand, kind of, wouldn't allow me to retreat? Okay, let's deal with blocking first. In particular, because of the context in which this encounter occurred, the large open area adjacent to the Lincoln Memorial, the blocking statement simply cannot be proven to be either true or false. Had the encounter occurred in a smaller confined area, a statement that one person was blocked by another might be objectively verifiable, but it's not here. Interestingly, plaintiff's response memorandum to a joint motion for summary judgment argues that blocking is factual because it involves the oppositional position of two human bodies in a confined space. But see, where I think that the court might be making a slight error here is what makes a space confined is not necessarily limited to the architecture of the space, right? So if you were in a hallway, the nature of the space being confined is confined by the hallway, like where the walls are and stuff. That's what makes it confined, is the hallways and the narrowness of the hallways. And the court sort of alludes to that, right? That's what would make that, confined. This I understand. All right. So you're in the big grassy area outdoors near the Lincoln Memorial or near the Washington Monument. Is it confined? Well, I mean, not normally, no. But in this particular circumstance, yeah, because remember, there were a lot of people there. There were a lot of people that are restricting movement. So maybe the nature of the space being confined is not being dictated by the walls, but being dictated by the crowd. What is making it confined, arguably, is the fact that you can't just move in any direction because not so much walls, but people. And the people are confining it enough. So I think the court might be making a bit of a mistake here on that logic, right? So in a hallway, it might very well be that what makes it blocking or not is the oppositional position of two human bodies in a confined space. Two human bodies in a confined space. But how about 1 million human bodies in an open space? Maybe it's the same logic. But as the videos depict, the area where this encounter occurred was huge outdoor spending, not a confined space. See, I think you might be making a mistake there because you're not considering, at least you don't seem to be considering, whether or not the people are relevant to determine whether or not the space is confined. And I think you need to at least consider it, and you're not. Further, Phillips' statement relied on assumptions concerning both Phillips and Sandmann's state of mind. If Phillips had no way of knowing what Sandmann was thinking or intended when he made the challenging statements, which kind of makes it worse in some ways, because he's assuming the maliciousness in his statement. The very fact he doesn't know could be a problem. It has long been established that someone's state of mind is not being capable of proving true or false. Yeah, but he didn't say, I felt confined. Maybe we're trying to transform the statement. If he had said, I felt confined, I felt like I couldn't move, then maybe that's different than I couldn't. So maybe we're trying to transform what appears to be an objective statement really into a state of mind statement. All right. Anyone is entitled to speculate on a person's motive from known facts of behavior. Okay. Courts have also found important the style of writing and its context, inserting what a reasonable reader would understand the alleged defamatory statement to mean. I'd just like to take a moment to thank the 455 of you who are currently watching. Thank you very, very much for you being here. I hope you're enjoying this analysis as we consider the court's position and we consider the court's analysis and we question parts of the court's analysis because there seems to be some issues here that don't appear to be quite adequately resolved. And I hope you're enjoying this. And as always, I want to just say thank you for being here. Let's read on some more and continue and consider the court's position with the appropriate level of care. For example, in some prior case from the First Circuit, one will take note, which makes it persuasive authority, not binding authority. The owner of a timeshare condominium sued a reporter who published an article in a local newspaper describing his encounter with a businessman, referring to it as a scam. After reviewing the Supreme Court libel precedent, the court first noted the word scam does not have a precise meaning, but means different things to mean different people. The court further observed that first-person narrative style on matters of public concern put the reader on notice the author is giving his views, and more commonly understood to be attempts to influence the public debate. This later observation applies equally to Phillips' statement. The media defendants were covering a matter of great public interest. I'm not even 100% sure that's true, to be honest, in a very sort of technical sense. The reason is because the media can't really bootstrap themselves into it being a matter of public interest, nor can they bootstrap him into being a matter of public concern, a public figure, right? So to be a public figure, the law is that you kind of have to do something to purposely avail yourself. You can't be forced into being a public figure through no action of your own, right? So if I sue you and it becomes really, really like a prominent lawsuit, you don't become a public figure. I cannot make you into a public figure. You have to make you into a public figure, right? You have to do something to avail yourself of the public. Now, what exactly that is and where those thresholds are is open to debate. So how much something do you have to do is a matter that's open to some debate, but you do have to do something. If you don't do anything, I can't bootstrap it by my very lawsuit. And here I think, is this a matter of public concern? The problem is that the media kind of makes it a matter of public concern. So they run into arguably the same bootstrapping problem. And I'm not sure to the degree to which the case law deals with this or not, one way or another, but it's at least a thought that passes through my mind. If I can't bootstrap you being into a matter of if I can't bootstrap you into being a public figure, maybe I can't bootstrap this into being a matter of public concern in order to get past this problem. Maybe it's the media themselves that are creating the public concern. And so basically they're trying to benefit from basically their own wrongful act in some way, in some sense. I don't know the degree to which the law supports this kind of a proposition. But it's definitely something I'm thinking about. I'm like, it's not inherently a matter of public concern. For example, the trial of any murder trial is basically inherently a matter of public concern. It's a murder trial. The public has a right to be concerned. So yeah, if you're trying to do this with Kenosha, for example, that's a matter of public concern. I still don't think he's I still don't think he's a public figure. But Rittenhouse, thank you. So I still don't think Rittenhouse is a public figure. Well, let me rephrase slightly. I don't think Rittenhouse was a public figure until recently. like after the trial ended, he might have become a public figure because he's done things to avail himself. But like before the trial, not so much. So like Rittenhouse might be a public figure now, but he wasn't a public figure, I don't think, at the time of the incident. He wasn't a public figure at the time of the trial, and he wasn't a public figure even at the end of the trial. He only became a public figure, if he became a public figure at all, after the trial ended, in my humble opinion. But it was a matter of public concern, so it didn't matter one way or another. And, you know, it doesn't run into this bootstrapping problem because, you know, it's inherently a matter of public concern when you're dealing with a murder trial. I mean, come on. But this, with the drumming and two people staring at each other outside the Washington Monument, this is a matter of public concern? I mean, maybe it is, but the court is just kind of assuming it into existence. So if the court is just kind of assuming it into existence, that's a matter of public concern? And I'm not sure it is. In the first instance, I'm not sure they can bootstrap themselves into this. Maybe they can, but there's something a little bit odd there. The media defends were covering a matter of great public interest. See, I don't think that's true. I'm not sure they were. They weren't covering something that was a matter of great public interest. It became a matter of public interest because of their coverage, but that flips the order around. And they're reporting Phillips' first-person view of what he experienced. That would put the reader on notice that Phillips was simply giving his perspective. Moreover, statements did not imply the existence of any non-disclosed fact. I'll give them that point. I think that much is true. There is no undisclosed fact. I think that's fair. And only under such circumstances does a statement of opinion loses constitutional protection. Yes, if it's a statement of opinion, which seems a little bit odd. Therefore, the blocking statements are protected opinion, and this would moot everything else. So, yeah, I don't know. The court seems to be making some assumptions here that don't seem quite proven. The court seems to be assuming this is a matter of public concern, which doesn't strike me as inherently obvious. The court seems to not be considering the possibility that the media is bootstrapping themselves into a matter of public concern, which maybe they can't do. And the court is also not apparently considering the fact that maybe the outdoor area of the Washington Monument, which I've been to before, and is in fact a big ass open space, but maybe the big ass open space is nevertheless a confined space because of not, for example, walls and doors, but because of people. Maybe somehow that changes it in some sense to a confined space. So assuming the premise that Phillips' statement would be actionable if they were in a hallway, if we take that premise, his statement would be actionable if they'd been in a hallway at the time, the court's analysis is not quite 100% clear on the issue of the crowds being the walls in the metaphor. So there seems to be some weaknesses here on this opinion. So I think that there's avenue to attack this. And the courts seems to be... So I have several questions in my mind about... And to the extent there's any case law on these points, obviously, as a theoretical appellate court or theoretical appellate attorney for this, these would be the things I'd be thinking about on appeal. Like, is there any case law at all that shows that otherwise open areas can be considered legally confined by the presence of people? Is there case law that supports that proposition? If so, cite that. Is there case law that deals with whether or not something is a matter of public concern? What establishes what that is, and whether or not the media can bootstrap themselves into that? Is there case law that deals with that? And so I think there's, again, I don't know the answers to these questions. I don't know the degree to which there's law that will support these propositions or not. But I've got questions. And the district court, at least, has not answered them in a way that seems satisfactory to me. So I don't know the degree to which Sandmann will be able to succeed on appeal. But I'm like, I don't know, man. Something about this seems a little bit off. Maybe there's grounds to appeal this. The court seems to be reaching some conclusions. I don't know. And these are pure legal questions, which is great for me as an appellate court or appellate court attorney. It's great for me because it's de novo, right? So if it was resting on findings of fact, I'd have problems. Because then I'm into, well, the court is the finder of fact. Trial court's the finder of fact. And, we're into clear error. No, that's the wrong one. We're into, abuse of discretion kind of analysis. Which either way. But we're not. The court is making pure legal determinations. Which means it's great for me as an appellate court. It's great for me as an appellate attorney because I don't have to give any respect to the district court in my argument. Because it's just like, appellate court, you don't have to give any respect to the district court, so they're just wrong. So would you fix this? So, all that good stuff. So I don't know whether or not the law supports his ability to appeal, but there do seem to be some areas of question. So I'll take a moment to answer any questions. That you have along the way, or respond to your comments. I'll take a quick look through the chat, see what we got. Why Kentucky law? It happened in D.C.? I'm honestly not sure about that, to be honest. I'm not sure why they're being sued in Kentucky. I'm not sure how they got past the issues with this being the appropriate place. I suppose the idea is that the publications occurred in Kentucky, at least in part. And so there's enough of a jurisdictional nexus there because the defamation occurred in Kentucky. So we're into basically Calder is the U.S. Supreme Court case on point. That there is enough publication in Kentucky to be sufficiently a basis for jurisdiction here. So the case that comes to mind about why we're able to sue in Kentucky is Calder, U.S. Supreme Court 1980-1981. Which dealt with the National Enquirer and whether or not they could be sued in California under similar. So that's probably why, if I had to guess. Luke says, probably depends on where the letter's published. If it's a scientific journal, then we've got to consider a different common man. You're absolutely correct, Luke. It absolutely does matter, right? Because the question is, who is the reader of the publication? And so, yes, it would absolutely matter. You're 100% right. It would absolutely matter if it was published in the New York Times versus Nature, because the nature of who's reading it is different. So, yes, what the ordinary common man on the bus looks like is a little bit different for those two things. So, yes, you're absolutely correct. The nature of where it's published absolutely changes who the ordinary common man is that is relevant to that. So, yes, that's a very fair point. Lady says, thank you for this live. You're welcome, Lady Autumn Sky. Thank you for being a member. Julia says, I'm liking your channel because you break it down and translate the legalese into English. Thank you. I try. And then I just give you my honest opinion. Sometimes I agree with the courts and sometimes not. And I'm like, And I'm not saying the court is wrong. The court might be right. But its explanations leave a little bit to be desired. And there's a little bit of a question mark. I'm like, no. So this like, I'm not sure, court. You seem to be making a little conclusory here. Maybe this needs to be considered a little bit more, but thank you very much. Excuse me. National media makes you public, says DL. Yeah, see, I'm not sure you can do that. That's the problem. I'm not sure that works. I don't think the national media can bootstrap its way in it being a matter of public concern. I'm not quite sure that works. I'm not sure because the national media decides to all cover it necessarily makes it a matter of public concern. That's the question that's kind of going through my mind. Does the fact that all the national media decides to cover it, does that mean it's automatically a matter of public concern? Maybe the answer is yes, but I'm not convinced. Because then it would allow the media to basically bootstrap themselves into being a matter of public concern. And I'm not sure they can do that. So maybe the answer is yes. If all the national media decides to cover the same story, maybe it means it's a matter of public concern. Maybe that just means per se it's a matter of public concern. I'm just not sure. I'm not convinced. I'm not convinced. Trish says, remember to subscribe. Thank you, Trish. Is the protest itself a matter of public concern? I don't know the answer to that question either, to be honest. There were a couple different protests going on at the same time. There was the National Right of Life protest, and then was an Indigenous Day thing protest. Are those inherently a matter of public concern? I don't know. I'm not sure if that works either. You might be right, but I don't know. Julie says, what would be the grounds of appeal? I thought I described that. The problem is the problem is that the thing the court is trying to decide is whether or not the statements are matters of opinion or matters of fact. That's the thing that the court's trying to decide. That's a pure legal question. Is it a statement of fact or is it a statement of opinion? And the court says, as a matter of law, they're statements of opinion. I'm like, I'm not sure. So the grounds of appeal is legal error. The statements are statements of fact. It's just pure legal error. Fuel Me One says, damn, you're good. Thank you. Basil says, when can we start challenging the reasonable person standard? That precedent was started back when reasonable people existed. People are rather dumb. I don't know. I think people are smarter than they've ever been, and the fact that's true scares me. Yeah. He's appointed by Carter. That doesn't necessarily mean he's wrong or right? I don't know. I'm not going to attack the judge because I didn't even check, nor do I care. Like, I didn't even look to see who is appointed by, because I don't care. Like, either his legal reasoning is persuasive or it's not. I don't give two shits who he's appointed by. I just don't care about if his legal reasoning is good. I've agreed with Sotomayor before. I agreed with her in Kansas v. Glover. We've talked about it before. I'm not a huge fan of Sotomayor, but she was the sole dissent in Kansas v. Glover. It was an 8-1 decision. She was the sole judge in dissent. I'm like, Sotomayor's right. You know? So I don't care. I just care how good their legal reasoning is or not. And here, this judge is like, well, I'm not so sure. These aspects of your legal reasoning seem a little bit questionable. You seem to be saying because it's in an outdoor space, it's therefore incapable of being confined. I'm like, I'm not sure that's true. And here's some facts that would suggest maybe not. You seem to be saying that that you seem to just be assuming that this is a matter of public concern. I'm not quite sure how you're getting there. You didn't cite anything the court didn't cite anything, by the way, as to what makes something a matter of public concern or not. They didn't cite, okay, here's how to determine whether something's a matter of public concern. Here's the relevant legal tests. I'm going to go do that now. They just said it's a matter of public concern. I'm like, how'd you get there? How'd you reach that conclusion? You know, so it's just like, you know, it's a little bit questionable. Anything else before I wrap it up? Okay. Well, it appears not. So I will simply thank you for your time. This has been enjoyable and fun. Ben says you can be arrested for dancing on a DC monument. Yeah. Don't do that. Did I see the Veritas case where New York Times said the words verifiable and deceptive do not have precise meanings that can be relatively understood? Did not. That's funny, though. All right, I'm going to sign off for now, guys. I hope you've had a good one, man. Remember to like, comment, subscribe, do all the YouTubey things. Thank you, guys, for all your concerns. I've discussed Citizens United versus FEC many times. Just search my channel for Citizens United. Yes, I think Citizens United was correctly decided. I think I have a couple videos. I think I even have a video explicitly titled "Why Citizens United Was Correctly Decided." But yeah, go search my channel. There's a video on Citizens United. I hope you enjoy that too. By the way, until later, I hope all is well. Cheers, my friends, and good night.